On the program today is my good friend Bo Berger, who is the president and COO of Rhinogram. We're going to be talking about texting and emailing patients, providers, and others today. A few preliminaries to get out of the way. I'm going to be talking primarily about the legal stuff, the rules that apply to texts or emails to patients, to other providers or other persons. I'm going to talk a little bit about that recent guidance that came out from CMS concerning text and orders and some general risk management issues. But I'm kind of the lawyer stuff, the stuff that you don't like to hear. Bo will give you more practical suggestions for what you need to do in order to comply with those laws when implementing appropriate solutions. You can submit questions today. We won't take questions over the phone. I don't think that we'll have time, plus our session is going to be recorded. But if you would like to submit questions, Bo and or I will respond to them offline. You can submit questions either by sending emails or using the chat feature on this program. We've provided you with a number of written materials. Hopefully you've got the link and you've got access to all of those, including a lot of the resources that I use to come up with the presentation and that are cited in my presentation. If you haven't looked at those resources yet, I'd encourage you to do so. We're going to be focusing, at least my aspect, my part is going to be focusing primarily on the HIPAA and CMS rules. But remember that the other rules may apply depending upon your circumstances. We've got people from all over the country. It's possible that your particular state laws or regulations may impose additional requirements above or beyond what we're talking about today. In addition, you got to be aware of maybe you've got contract requirements. Maybe you are a business associate, and as part of that business associate, you've got an agreement that places additional restrictions. So you got to not only be concerned about applicable law, but contracts that may apply to you, or your accreditation requirements. In addition, aside from the strictly legal issues, you need to be concerned about the risk management issues that may be involved, which brings us to our first point of discussion, to text or email or not text or email. There are pros and cons to texting or emailing. The pros are, when it comes to texting, it's a common means of communication. For those of you who've got teenagers, it's kind of hard to talk to your kids anymore. In order to get communicate with my kids, it seems like I have to send them a text. It is pervasive out there and is only going to become more so with the rising generations. Also, it's available anywhere, so long as you've got your smartphone, and it's instantaneous. You can, as long as you've got your smartphone with you, if you're in the middle of a concert, you can look at that text. You can send the text. You don't have to get to necessarily a place where you don't be overheard. It avoids phone tag. You can send that text. You don't have to wait to actually talk to anybody. You can send that text, and the text is on its way, and it's there for the people to read. Hopefully, it's going to reach the recipient when you send it. And the bottom line, because of all of those reasons and simply because of the type of people we are these days, providers are demanding being able to use text. Your employees, others, they want to be able to use the text because it makes their life easier. Now, with all of those pros, there are still cons to using text. So even though the law may allow you to use text, you may decide that you don't want to because of the risk management issues, or at least you ought to consider that in developing your policies. One is, those texts that are sent out, they're subject to errors. For any of you who send out that text and had that darn autocorrect change whatever it was you send out, you know that sometimes those texts aren't all that reliable and it may be prone to errors. Even if you do send out the right information in text is likely cryptic, and so it may be subject to misinterpretation on the other side. Also, when you send out that text, it's probably not going to make it into the medical record unless you put in place policies or practices or solutions that are going to send it there. So now you're making treatment decisions, giving orders or the like, but it may not, those orders, the reasons for what you're doing, the directions may not actually appear in the medical record. It's possible to send it to the wrong recipient. We've all done that. We send text to people we didn't think that we were sending the text to, and of course that could result in HIPAA violations. You may not be able to authenticate the recipient. You send it out there, but you don't know for certain whether the right recipient got it or if and when they received it. You may not be able to confirm that they actually did get it. You send it out there, you assume that they got it, but they may or may not pick up their text, so they may have changed their phone number or whatever. So there's no absolute certainty that the person not actually received it unless they respond. The receipt may be delayed. you send out the text, but you don't really know if and when that person on the other end is going to receive it, unlike a phone call when you're actually talking to the person. When you do send down that text, it's maybe stored on an unsecure device, particularly if you send it onto a private phone or bring your own device phone, then it may be on that unsecured device. That device may not be secured, and if it isn't and it's lost or stolen, then hey, now you've got HIPAA or data breach issues. Even if the device at the end is secure, the server that is used to store that information or to send that information, it may not be secure, and so that raises regulatory risks, which brings us to the regulations that may apply. Most importantly, it's the Health Insurance Portability and Accountability Act, or HIPAA. HIPAA, of course, applies to all of you who are healthcare providers. If you engage in certain electronic transactions, it also applies to your business associates, those entities with whom you share or who maintain your protected health information, including cloud service providers who maintain protected health information on your behalf. What does it apply to? Well, it applies to protected health information. I've had this. Some people say, well, we can go ahead and send the text. We'll just, include the patient's name or their account number or something like that. But as long as we don't provide any, detailed information about what's going on, then there's no HIPAA violation, right? Au contraire. HIPAA applies to protected health information, which is defined as any individually identifiable health information that could be used to identify the individual that concerns a physical or mental health, healthcare, or payment that's created or received by a covered entity or its business associate or other person in its capacity as a healthcare provider, maintained in any form or medium, whether oral, paper, electronic, images, etc. So just simply things like the patient's name, if it's sent in conjunction with any indication related to treatment, then or healthcare or payment for the healthcare, then that's going to be protected health information. If you question that, just look at the HIPAA rules concerning de-identification. If you de-identify the information, if you go in and suck out all the identifying information, then it's no longer protected by HIPAA, and you can send that. But the HIPAA regulations contain a list of what information you would have to suck out in order to de-identify it. Look at some of those things that you'd have to take out: names, physical addresses, birth dates, telephone numbers. If you're sending the patient's health information, even if you don't put the patient's name in it, if you're sending it to their telephone number, it's kind of hard to see how that would not be protected health information. Email address, similar, or mail addresses, social security numbers, medical record numbers, account numbers. I've had that. What if we just put the patient number on there or the medical record number on there, but we don't include the patient's name? Is that protected? No, that's still an identifier. That's identifiable health information. Device identifiers and serial numbers, URLs, Internet Protocol IP addresses, full-face photographic images or any images that are individually identifiable, or any other unique identifying number, characteristic, or code. The bottom line is it's kind of hard to see how you're going to send any information that's going to be helpful when it comes to protected health information that's not going to, or applies to the treatment of the patient, that's not going to contain some kind of protected health information. And if it's going to involve protected health information, you got to be concerned about HIPAA, the privacy rule, the security rule, and the breach notification rule. All of those apply. What happens if you violate HIPAA? Well, the penalties were recently increased. Now the penalties, because of the cost of living adjustment, is up to $112 to $55,000, or about $56,000 per violation. Now, the range depends upon your intent. If you act with willful neglect, it's a mandatory fine of at least $11,000 up to about $56,000 per violation. If you correct it within 30 days, even though if you act with willful neglect, the fine's about the $11,000. On the other hand, if you act with willful neglect and you don't correct it within the 30 days, it's a mandatory fine of at least $56,000 per violation. Those fines can add up quickly. The good news is, if you don't act with willful neglect and you correct it within 30 days, then that's an affirmative defense to HIPAA penalties. You still may be subject to lawsuits or bad PR or the other stuff, but at least you can avoid HIPAA civil penalties. Take a look at just the HIPAA settlements that have come out from the Office for Civil Rights over the past year. And look at those. Most of those, if not all of them, could apply to your situations where you're texting or emailing information that has not been secured. So you really got to be careful about this stuff, including storing things on unsecured devices, using unsecured methods to transmit it, or look at that last one, the failure to timely report a breach. So you had a breach of protected health information, you didn't report it properly, you can get hit up with, in this particular case, that entity got hit up with a $475,000 fine. But the fines could be much, much larger, because if you know you have a reportable breach and you fail to report it, that is probably willful neglect, which means that's a mandatory fine of $56,000 per violation. And for every person's name, every patient whose information was violated or breached, that's a separate violation. So those HIPAA penalties and fines can add up really, really quickly. The bottom line is you need to make sure that you comply. So when we're talking about emailing and texting, what are the rules that we really need to be concerned about? Well, under the privacy rule, the general rules are you've got to ensure that any use or disclosure is for a permissible purpose. If you're going to be sending out or disclosing that information to another, for example, for treatment purposes or disclosures to families, if you can do that appropriately under the regulations, unless you get the patient's authorization. In addition, you've got to implement reasonable safeguards to protect the information. You've got to limit the disclosure to the minimum necessary, so don't be disclosing more in those texts or emails than is minimally necessary. And you've got to verify the identity of the recipient. So make sure that before you send that you know who you're sending it to. In addition, the HIPAA privacy rule also gives patients certain rights concerning their information we're going to talk about in just a minute. It's those rights that really play a big part in compliance with the privacy rule. But you also got to be concerned about the security rule. And it's really the security rule we're most concerned about when we're talking about emailing or texting. Under the security rule, the ones that are most applicable to emailing and texting, the covered entities and their business associates. Under the omnibus rule, business associates are obligated to comply with the security rule just like covered entities are. They've got to conduct a risk assessment of their electronic protected health information, and that risk assessment better darn well cover emailing or texting if you're emailing or texting protected health information. And you've got to implement appropriate administrative, physical, and technical safeguards that are all set forth in the security rules. Specifically, with regard to emailing and texting, you've got to have access controls, meaning you've got to have unique user identifications, automatic log-offs, encryption, and you've got to protect the data in transmission, including you've got to have integrity controls, and again, you've got to have appropriate encryption. Now note that some of those standards are addressable. Some are required, but some are addressable. What does it mean to be addressable? Well, under the security rule, when a standard includes addressable implementation specifications, a covered entity or business associate generally has to implement that addressable standard unless you determine that it's not reasonable and appropriate. If you determine it's not reasonable and appropriate, maybe you think that, well, gee whiz, I think it's appropriate for me to text, but I really need to text my providers. It's not reasonable to believe that I shouldn't be able to text them. Well, even then you've got to document why it would not be reasonable and appropriate to implement, in this case, let's say, encryption. And you've got to implement an equivalent alternative measure if it's reasonable and appropriate. So you can't just say it's unreasonable. You've got to come up with an alternative that's reasonable. Well, how does that apply to encryption? Is the use of encryption mandatory under the security rule? Well, the OCR gave us an FAQ on this. They answered and said, no, the final security rule made the use of encryption an addressable implementation specification. It must be implemented if, after a risk assessment, the entity has determined that the specification is a reasonable and appropriate safeguard in its risk management of the confidentiality, integrity, and availability of EPHI. If the entity decides that the addressable implementation specification is not reasonable and appropriate, it must document that determination and implement an equivalent alternative measure. So you want to use unencrypted email or unencrypted text? Well, you're going to have to convince the OCR that it's not reasonable under your circumstances, and you're going to have to come up with an alternative that provides basically the same level of protection. That's probably hard to do given the ubiquitous nature of HIPAA compliant or at least helpful protective solutions that are out there. So the general rule of thumb is, hey, you need to make sure your emails and texts are secure. So let's talk about applying some of those rules to emailing and texting. First, let's talk about emailing or texting back and forth with patients. When you're talking about communicating with the patients, you've kind of got this balance, this tension between the security rule, which says, hey, you got to protect this stuff, you got to encrypt it, you got to make sure that it's protected, versus the privacy rule, which requires protections, but it also gives patients a right to receive their communications by alternative means or alternative locations, including the right to receive communications via unsecure methods. So the government has issued the following FAQ. Does the HIPAA privacy rule permit healthcare providers to use email, or we might extend that to text, to discuss health issues and treatment with their patients? Yeah, sure, you can go ahead and do it, but you got to comply with the privacy rule, implement appropriate safeguards. What might that be? Well, according to this, certain precautions may need to be taken when using email or text to avoid unintentional disclosures, such as checking the email address for accuracy before sending, or sending an email alert to the patient for address confirmation prior to sending the message. Further, while the privacy rule does not prohibit the use of unencrypted email for treatment-related communications between healthcare providers and patients, other safeguards should be applied to reasonably protect privacy, such as limiting the amount or type of information disclosed through the unencrypted email. So can you do it under the privacy rule? Yeah, generally, just put in place those safeguards, but compliance with the privacy rule is not everything you must do. You've also got to comply with the security rule. There's the rub. What does the security rule require? Well, in the FAQ, the government said, does the security rule allow for sending electronic EPHI in an email over the internet? If so, what protections must be implied? The answer is, you got to comply with the security rule. It does not expressly prohibit the use of email for sending EPHI. However, the standards for access control, integrity, and transmission security have to be satisfied. That means that you've got to implement policies and procedures to restrict access to, protect the integrity of, and guard against unauthorized access to EPHI. The standard for transmission security also includes addressable specifications for integrity controls and encryption. This means that, here's the key, the covered entity must assess its own use of open networks, identify available and appropriate means to protect EPHI as it is transmitted, and select a solution and document the decision. Again, the assumption is you got to encrypt the stuff. The security rule allows for EPHI to be sent over an open electronic network, including SMS text or an unsecured network, so long as it is adequately protected. Well, so what do you need to do then to communicate with the patients via unsecured email or unsecured text? The key here is the government basically said, well, you know, those patients have a right to receive their information by alternative means or alternative locations, so they can agree to receive information by unsecured email or unsecured text. But we want to make sure that they're aware of the risk before they agree to receive that. In the Omnibus Rule commentary, some of the people said, hey, they submitted comments to the OCR and they said, we want to be able to communicate with our patients via unsecured email or text. And the government said, yeah, that's fine, but you've got to make sure you notify the individual. Covered entities are permitted to send individuals unencrypted emails or texts if they have advised the individual of the risk and the individual still prefers the unencrypted email. People complained that, well, that's too much of a burden. The government refuted that. They said, we disagree that the duty to warn individuals of the risks associated with unencrypted email would be unduly burdensome on covered entities and believe this is a necessary step in protecting the protected health information. We do not expect covered entities to educate individuals about encryption technology and the information security, so you don't have to send them a brochure or the NIST standards for encryption or anything like that. Rather, we merely expect the covered entity to notify the individual that there may be some level of risk that the information in the email could be read by a third party. If I were drafting some kind of a notice, I would probably parrot that language. Hey, patient, we're happy to communicate with you via unsecured email or text, but just be aware that there may be some level of risk that the information in the email could be read by a third party. If individuals are notified in the risks and still prefer the unencrypted email or text, the individual has the right to receive protected health information in that way, and covered entities are not responsible for unauthorized access to protected health information while in transmission to the individual based on the individual's request. So, you want to communicate with your patients via unsecured email or text? Make sure you notify them in advance of the potential risks, and if they agree to it, then, hey, you can go ahead and do that. Must you get them to sign some specific form? No, there's no requirement for that, although certainly it will help you if there's ever any kind of a change down the road. Does it have to be a HIPAA-compliant authorization? No, you just want to document something that you gave them notice and they otherwise agreed to accept it in that method or manner. Note here that not only may patients agree to that, if they request that, then you generally have to comply with those reasonable requests. And in the government's recent guidance concerning access, they assume that you've all got the ability to email patients. So if a patient wants their information via email, then the government generally assumes that you've got that capability and you should be able to respond and comply with the patient's request to send them the information by email. More recently, in the government's guidance to access, the government reaffirmed that if covered entities or if patients want that information via unsecured methodology, the covered entity must provide a brief warning to the individual that there is some level of risk that the individual's PHI could be read or otherwise accessed by a third party while in transit, and confirm that the individual still wants to receive her PHI by unencrypted email. If you do that, then you should be okay in communications with the patient. Well, what about if you do that and somebody accesses the information improperly? Well, that's not your problem. As long as you're doing it at the patient's request and somebody improperly accessed it, then it's not your fault. That's not a breach on your behalf, and you don't have to even report it as a breach under the breach notification rule. So covered entities are not responsible for a disclosure of PHI while in transmission to the individual based on the individual's access request to receive the PHI in an unsecured manner. That's assuming that you gave the patient adequate warning. Well, so HIPAA would allow us to do this. Could we just go in and require all of our patients to agree to receive text? Not give them the option, just tell them, hey, if you want to do business with us, if you want to receive our services, you have to agree to receive communications via unsecured email or text. Can you do that? No, probably not. The several different provisions in HIPAA prevent you from requiring patients to waive their rights under HIPAA, including their rights to have their information secured. So you generally can't force that on them. Okay, that's text and emails you want to send to the patient. What about if the patient just simply contacts you by email? Are you justified in assuming that, hey, patient said it was okay, apparently. I'm going to go ahead and communicate with them via unsecured email or text. The government in an FAQ basically said, yeah, generally so. The security rule does not apply to the patient. The patient can choose all day long to communicate with you via unsecured method, but the security does apply to you. A patient may send health information to you using email or text that is not secure, but once you receive it, then you've got to secure that information. If the patient initiates communications with the provider using the email, in that situation, the healthcare provider can assume, unless the patient has explicitly stated otherwise, that the email communications are accessible to the individual. Therefore, you can go ahead and communicate with the patient via unsecured method, unless you think that the patient may not be aware of the potential risks. If the provider feels the patient may not be aware of the possible risks of using unencrypted email or has concerns about potential liability, the provider can alert the patient of those risks and let the patient decide whether to continue email communications. To be safe, if you get the email from the patient or the text from the patient that's not secured, I would go ahead and respond before disclosing any sensitive protected health information and notify them that, hey, we received your unsecured email or text. just note that that creates some level of risk that may be accessed by third parties. Do you still want to communicate via unsecured email or text? If they say yes or continue, then I think that you're justified in going ahead and communicating via unsecured email or text. The AMA actually recently published guidelines for emailing patients. I provided that in the materials to you. I think it actually provides some really helpful guidance for physicians and other healthcare providers in assessing and coming up with policies relating to appropriate emails or texts with patients. So I would commend that to you and suggest that you might want to take a look at that. All right, we've been talking about emailing with patients. What about emailing with others who are not patients? Whether it's your business associates, whether it's other providers, either inside or outside your organization, or other persons, family members, whoever it might be. What are the rules there? Well, the FAQ, the government published an FAQ. It says, does the HIPAA privacy rule permit a covered healthcare provider to email or otherwise electronically exchange PHI with another provider for treatment purposes? Yeah, you can go ahead and do it. You just got to make sure that you've got reasonable safeguards. Among other things, though, you need to make sure that you're complying with the security rule, because it's not enough to comply with the privacy rule. You've also got to comply with the security rule. Well, what about the security rule? The government issued an FAQ specifically dealing with email or text to other healthcare providers. Can you use texting to communicate health information, even if it is to another provider or professional? Answer, it depends. Good lawyerly response. Text messages are generally not secure because they lack encryption and the sender does not know with certainty the message is received by the intended recipient. Also, the telecommunication vendor / wireless carrier may store the text messages. However, your organization may approve texting after performing a risk analysis or implementing a third-party messaging solution that incorporates measures to establish secure communication platforms that will allow texting on approved mobile devices. What does that mean? You got to comply with the security rule if you're going to be communicating with others. Well, then the question is, what about this? What about if we went to our patients and asked our patients to authorize our internal communications with providers or other providers via unsecure means? Could the patient authorize us to use unsecured texting or emails to communicate either internally or with other providers? It's not real clear how the OCR would respond to that situation. Personally, I think that they ought to be able to do it. Why? Because, you know, HIPAA was primarily intended to protect the patient, right? So as long as the patient understands the risks, and it seems to me that they ought to be able to approve texting via unsecured methodology. But there are arguments against that. Remember, providers are generally required to comply with the security rule. A covered entity may not require individuals, so you couldn't require your patients to authorize this texting between your providers via unsecured email. And in the guidance that the government gave us on OCR guidance for access, the government drew a distinction between requests from the patient to transfer your information to a third party or authorizations that are initiated by the healthcare provider to disclose information to a third party. Under that guidance, which I've provided to you, it specifically says that if an individual requests that you transfer the records to a third party, that's part of the patient's right to access. That means the patient could come in there and tell you, hey, I want you to send my records via unsecured mail to a third party or unsecured text to a third party. If they request that, then you not only may do it, but you're generally obligated to do it if you've got the reasonable ability to do that. In contrast, however, if that request is initiated by you and you seek authorization, the guidance that came out says that in those situations you would generally need to use a secure transmission to transmit that information. So it may come down to who's requesting that particular information. The government came out with the following guidance. If it's requested by an individual, a covered entity must transmit an individual's PHI directly to another person or entity designated by the individual. The individual's request must be in writing, signed by the individual, and clearly identify the designated person or entity and where to send the PHI. That the individual can designate the form and format of the PHI and how the PHI is to be sent to the third party, including they may authorize sending that information via unsecured text. Again, the government said covered entities must safeguard the information in transit and may be liable for impermissible disclosures of PHI that occurred in transit. So, for example, if you're using an unsecured SMS text. The only exception arises when an individual has requested that the PHI be sent to the third party via by unencrypted email or in another unsecure manner, which the individual has a right to request, as long as the individual was warned of and accepted the security risk to the PHI associated with the unsecured transmission. The covered entity is not responsible for a breach notification or liable for disclosures that occur in transit. I think that that commentary could probably use to support the patient giving you some kind of a waiver or some kind of authorization to allow you to communicate with others, providers internally in an unsecured manner. But again, we don't know exactly how the OCR would respond to that. That's a bit dangerous. All right, so that's talking about general texting, emailing within your organization or outside your organization with other providers. Special rules apply when it comes to facilities, because facilities are governed not only by HIPAA, but they're also governed by the Medicare conditions of participation or conditions for coverage. If you want to participate in Medicare, then there's strings attached. Some of those strings attached govern things like records. Now, the Joint Commission, for those of you who don't know, the Joint Commission comes in and accredits entities to make sure that they comply with the conditions of participation. The Joint Commission and CMS have kind of had this love-hate relationship or this varying relationship with texting over the past few years. In 2011, the Joint Commission prohibited texting. In May of 2016, the Joint Commission reversed itself and allowed texting orders if the platform was secure, and certain other conditions concerning that order were included. A couple of months later, the Joint Commission reinstated its prohibition, said, oops, maybe not quite so fast. It reinstated the prohibition on texting orders while it obtained clarification. In December of 2016, the Joint Commission came back and reaffirmed the prohibition on texting orders for certain reasons. They've said that we don't want you texting orders, you individuals, you entities that are participating in Medicare who are governed by the conditions for participation or the conditions for coverage. We don't want you texting orders because it places an unreasonable burden on the nurses to manually input that order into the medical record. That a verbal order would normally allow for real-time clarification and confirmation, which doesn't exist in a text. And if you've got an electronic medical record system that flags alerts along the way, then that may not be flagged if you've got this, if you just have a text in order, that you don't have that safeguard. So they came out and said you can't do that. Now back in December, actually it should be in December of 2017, HCCA, the Healthcare Compliance Association, published an article in which they cited several cases in which CMS took it a step further and said, hey, you can't only text orders, but you can text any protected health information, any information within your particular facility. That caused a big stir, resulting on December 28, 2017, the CMS coming out with guidance concerning texting. And here's the rules from that guidance. This is the latest thing that has come out under the Medicare conditions. Texting patient information among members of the healthcare team is permissible if accomplished through a secure platform. On the other hand, texting of patient orders is prohibited regardless of the platform utilized. So you can't text orders, but you can text not orders, just questions or other protected health information if it's a secure platform. They reaffirmed that computerized provider order entry, or CPOE, is the preferred method of order entry by a provider. Specifically, they explained why they were prohibiting texting orders. They affirmed that in their opinion, CMS, that it violates the conditions of participation and conditions for coverage. For example, hospitals must maintain medical records and protect the security of record entries. if you're texting those orders, then text may not make it into the medical record, and therefore you may not be complying with the conditions of participation there. In addition, hospitals must maintain records under the Medicare conditions of participation for at least 5 years, so that information that appears in text may not satisfy that condition. And hospitals must protect the confidentiality of records, and if you're texting via an unsecure platform, then that may not satisfy that. Those are just some of the conditions that they said texting orders would violate. They reaffirmed that with regard to computerized provider order entry, that that's the preferred method. CMS has held to the long-standing practice that a physician or licensed independent practitioner should enter orders into the medical record via handwritten order or via CPOE. So there's your options, via handwritten order or via CPOE. An order, if entered into via the CPOA with an immediate download into the provider's electronic health records, is permitted, as the order would be dated, timed, and authenticated and promptly placed in the medical record. That doesn't necessarily apply to texting orders. Texting orders doesn't satisfy that standard. CMS and the Joint Commission appear to have reaffirmed their concerns about texting orders. Again, by texting those orders, it places a burden on the nurses to manually input that order into the medical record. That verbal order, if you're doing it instead of by text, you're having the verbal order, it allows for that real-time clarification and confirmation. Those concerns that led the government to prohibit texting, those still remain, even if you enter the text as a verbal order. So I've gotten that question sometimes. Can you just simply treat that text in the order as if it's a verbal order and go ahead and implement that? Based on this commentary, I don't think so, because the concerns about texting orders still apply to that text. So I don't think that you can simply treat that text as a verbal order. In addition, the conditions of participation reaffirmed that if verbal orders are to be used, they're to be used infrequently. And when verbal orders are used, they must only be accepted by persons who are authorized to do so by hospital policy and procedures consistent with federal law. So if you've got this policy where you're regularly texting orders, well, that's not going to comply with the conditions, because you can't just treat those texts as if they were verbal orders, because verbal orders must be used infrequently. When you look at the commentary that came out concerning the changes, they reaffirm the possibility of errors associated with verbal orders, that's an important issue, and that's why we continue to believe that hospitals should make efforts to minimize the use of verbal orders. It is expected that the standard practice would be for the person taking the order to read the order back to the practitioner to ensure that they have correctly understood it. So simply sending text isn't going to satisfy that concern, because you don't have that feedback for permissible verbal orders that allows confirmation. In the interpretive guidelines that came out concerning those verbal orders, again, the government reaffirmed that verbal orders, if used, must be used infrequently, that it can't be a common practice, which may apply if you're trying to treat your text as verbal orders. Verbal orders pose an increased risk of communication, which would also apply to text, that could contribute to a medication or other error resulting in a patient adverse event. The government reaffirmed that verbal orders should be used only to meet the care needs of a patient when it is impossible or impractical for the ordering practitioner to write the order or enter into an electronic prescribing system without delaying treatment. Verbal orders are not to be used for the convenience of the ordering practitioner. The content of the verbal orders must be clearly communicated. CMS expects nationally accepted readback verification practice to be implemented for every verbal order. All verbal orders must be promptly documented in the patient's medical record by the individual receiving the order. Again, texting orders probably would not satisfy that. All providers must utilize and maintain. Okay, so generally, I don't think that you can simply use those texting orders, treat that as if it were a verbal order and still comply with the conditions. We haven't received specific guidance on that, but I think that it's dangerous. So, general rule is, if you're covered by the Medicare conditions, then you generally can't text orders. Well, what about other communications? Government said in its guidance, yeah, you can do it. CMS recognizes that the use of texting as a means of communication with other members of the healthcare team has become an essential and valuable means of communication among the team members in order to be compliant with the COPS or CFCs. All providers must utilize and maintain system platforms that are secured, encrypted, and minimize the risk to patient privacy and confidentiality as per HIPAA regulations and the COPS. So bottom line is, generally, you can go ahead and use unsecured email and text so long as you can satisfy the security rules. Security rules generally require emails to be secured, text to be secured, so that's going to create some issues unless you can satisfy that addressable standard. If you get the patient's consent, you can generally use unsecured email or text to communicate with the patient. That doesn't necessarily apply to other providers. General rule for providers is that you can use secure platforms to text other providers, except when it comes to texting orders. For orders, you generally can't use text to communicate. A couple of other items real quickly before I turn it over to Bo. You've got to be also concerned about not only the information that's being transmitted, but also the information that's stored on that mobile device. If you're texting in the orders, it comes in, that data is now on that mobile device or other device, and you better darn well make sure that that is protected. If not, you can get hit up with huge fines or penalties. In this particular case, entity had to pay $2.5 million because the laptop was lost and there was insufficient security protections. That could also apply to the loss of a mobile device. Another entity had to pay $2.2 million because they lost a USB that wasn't encrypted. More recently, an entity lost an unsecure mobile device. They had to pay $650,000. In this publication that came out, the news alert on that, the director of the OCR stated that mobile devices in the healthcare sector remain particularly vulnerable to theft and loss. Failure to implement mobile device security by the covered entities and business associates puts individual sensitive health information at risk. This disregard for security can result in a serious breach which affects each individual whose information is left unprotected. And remember that the number of violations, that could be the number of persons affected, each of those individuals for whom you have information in your cell phone that gets lost, that's multiplied by, could be up to $10,000 to $50,000 if you act with willful neglect. That can result in significant penalties. Remember, for the data that's stored on your device, you got to implement the security requirements, which would include unique user identification, such as passwords, process for emergency access, automatic log off or auto lock, and presumably encryption. The government's issued a very helpful website dealing with mobile device security. If you're not familiar with it, I'd encourage you to access that on the helpit.gov. Some additional HIPAA considerations. If you're going to contract with a vendor out there, either to help transmit your PHI or the like, then chances are you're going to need a business associate agreement with them. It does not, if they are maintaining the protected health information, if they're a cloud service provider, they're maintaining the information, you need a BAA with them. That was made clear in the omnibus rule. If all they are mere conduit, so they never access it and they're not maintaining the information, not storing the information, but they're just transmitting it, just the conduit, then you would not need a business associate there, business associate agreement. The failure to implement a business associate agreement, the government's been cracking down on that. This entity had to pay $31,000. Another entity had to pay $1.55 million for, among other reasons, they didn't have a business associate agreement with their cloud service provider. Remember also, under the privacy rule, the patient has a right to access their information that's maintained in your designated record set. That designated record set is generally the information used to make healthcare decisions concerning the patient or their patient, which could include text, which means the patient may have an obligation to, or may have a right to access information that's maintained in text. Now, this doesn't necessarily, HIPAA doesn't necessarily require you to maintain those texts. You only have to grant them access of the information that you actually maintain. But if you do maintain those texts out there, if they're stored in your system, then that patient may have a right to access that. Separate and apart from HIPAA, as we mentioned earlier, or CMS mentioned, other laws or regulations may require you to maintain those records, which could be interpreted to extend to text. And if there is a breach of unsecured protected health information, you have an affirmative obligation to narc on yourself. You've got to report to the individual, also to HHS. The unauthorized access use of disclosure in a manner that's not permitted by the privacy rule is presumed to be a reportable breach unless you do that risk analysis. Well, so what is the covered entity's obligation under the breach notification rule? Is it obligated to report a breach if it transmits an individual's PHI to a third party designated by the individual in the access request and the entity discovers the information was breached? Well, yeah, you're responsible if the breach occurred during transit unless the patient requested that you send the information via unsecured method. If the patient requested it, then it's not on you. It's not a reportable breach. What happens if you've got a problem and you simply don't want to disclose it because you don't want to be hit up with those fines? That's very dangerous because, as I mentioned earlier, the government's given an example where somebody lost a laptop, it wasn't encrypted. They decided they weren't going to report that because they were concerned about the PR. The government said, that's willful neglect. That means you can get hit up with those penalties of $56,000 for violation. All right, that's a brief review of the legal aspects of this. I'm going to turn it over to Bo now to talk about more of the practical solutions when it comes to this stuff. Bo, can you take it away?
Absolutely. Thank you very much, Kim. Yeah, I want to keep my section pretty high level. I mean, when we spoke earlier about this and about the content we would deliver, we certainly can go very deep in the technology. But for cases of understanding what you should or shouldn't do with texting and how might you implement a solution, we wanted to keep this high level and give some education on the technology. And similar to what Kim said when we started is we're living in a world now where patients want to text. We're living, every individual now probably is texting. It's very, very large. And as we've done surveys, we've discovered that people really want to do this with their providers and with their healthcare professionals. So as it relates to the possibility of a patient asking the question, will you send me something via text, it's likely going to start happening more and more frequently. And so it's very important that you come up with a solution to do that. And as we saw, there's a lot of pitfalls with the technology and things you need to implement to actually execute that idea. But the trick is and something I get a lot of questions about is what really is texting and what's the detail when somebody says, would you just text with me? Some of this might be quite obvious, but there's some details behind the technology. When we say texting, we like to include just about all forms of texting. In one scenario, SMS, if you ever heard that terminology before, that is the acronym that short message service and multimedia service. Those are two different acronyms that represent what the carriers are supplying. So a lot of the smartphones and non-smartphones that are out there are using primarily, when it's only texting, the SMS standard, and that's what you're getting delivered. In many cases, when you're using the technology from Apple and some other smartphones, you may not actually be using real SMS. When you text between Apple devices, you're actually technically staying on Apple's network, and so you're not actually texting via SMS, you're actually texting really just on Apple's network. So when somebody says to you texting, it actually is pretty broad. It also includes what we do all the time with our family members and our friends, and when we do Facebook and Twitter and other applications out there like WhatsApp. This is all texting. It could be on somebody else's network. It could be on the carrier's network. It could be in a private network. And a lot of times when patients log into portals, and they may even text to the portal, that's another way of texting. So when we like to think of it from a technology standpoint, just because we say texting doesn't mean you're supplying any one technology. It can come from many different forms. So if we look at texting, and as Kim has mentioned earlier, the real complication is the HIPAA compliancy may get in the way for us just thinking it should be simple for us to text. So I'd like to break down the texting into two kinds of thoughts. One is, what is the secure texting and what is insecure texting? So secure texting, you should think about really two aspects of it. Primarily, a lot of the words that are thrown around are like encrypted texting or encrypted technology. The reality is whenever you're on a browser and you see that little lock show up, that is when somebody has turned on the encryption in your browser, and the communication from the server that's bringing up that website to where you see it on your browser, on your desktop, that is encrypted. The data got scrambled, if it was ever intercepted in between the transmission from the server to your browser and somebody looked at it, it would just be a bunch of ones and zeros, and they really wouldn't understand what it was intended to be or what the real data was unless they had the special key that only the provider of the technology would have. So that's the benefit of encryption when it goes all the way from the transmission point to the endpoint. So if you're texting with somebody and you truly have secure texting, what they're talking about is the transmission of that data is secure all the way. Now, security also encompasses the concept of what happens when that data is actually sitting, what's called in technical terms, at rest. And at rest encryption means that the data, when frankly nobody's looking at it and it's sitting on your server, is also encrypted. So you've heard the idea of the hard drive being taken off of somebody's desk or the laptop being stolen. There's no transmission occurring at that point, but there is data. When somebody gets that data, can they just open the file and look at it? If it's encrypted, then there's, again, a protection in place where no one can get access to it. So secure texting, I like to think of it as kind of a closed system where both parties that are trying to texting are inside the world where they've probably logged in and are inside an environment where both parties know that the transmission and the delivery is encrypted and gets to the other side securely. So now insecure texting is a different way of thinking about it, because I think technically insecure texting is really the opposite of having encryption, whether or not it's being transmitted or it is at rest encrypted, but it may include technology that actually is secure, but you just don't have any control or know that it is secure. So as we look at the rules that are in place, you're responsible for knowing whether or not the information is delivered securely. So if you don't know that, even though it might be, you still need to consider that to be insecure. In many cases, when you're communicating on Facebook, you probably are completely secure. And if you watch it on your browser, you see the lock on, and they are keeping everything secure. But as a provider and as implementing a strategy for technology, if you're transmitting across Facebook, you don't have any control over that security. So in that case, you should consider that to be insecure texting. And the same thing will be true with the carrier. Carriers transmit, sometimes it's secure, sometimes it's not secure. Sometimes it's secure during the transmission by the carrier, but sometimes when it gets delivered and it's on your handset, it may become insecure. So it gets difficult, but basically when you're looking at a system and you're looking at what you are truly doing, if you have control, you're probably doing secure. If you don't have any control over it, it's insecure. So let's look at the benefit. If you look at the HIPAA side of this and you're looking for finding a solution from a third-party provider or building your own solution, there's several things that I want to speak about that allows you to kind of make good decisions about it. So let's start with the HIPAA side of it. On the business associate, and Kim mentioned this earlier, having a business associate agreement in place is a key component. If you find a vendor that's got a really good-looking technology, works the way you would expect your workflow to work, and you can implement it, you still have to have a business associate agreement in place. You should also ask the questions from that provider of what agreements do they have in place with some of their technology providers. So even if you go to a third party, most likely the third party is not supplying or has not created 100% of the technology themselves. That may include the server technology that they're housing the data. It may include some of the transmission methods. It may include the technology on the handset, whether it's app-based or not. A lot of these technologies, it's becoming easier to develop solutions these days because there's lots of vendors offering up developers ways to quickly connect services together. That doesn't mean that all those services that are connected together, even though you signed the business associate with the main provider or your main third-party supplier, has all agreements in place. So it's reasonable for you to ask those kinds of questions and see what you get as answers to know that you've got the full solution in place. So one of the things that we think is really important to consider when you are talking on a phone call and you are talking about minors or adult patients, and depending on the scenario of your area of healthcare expertise, in many cases, if you're talking to pediatrics or you're talking to orthodontists and other kinds of suppliers, you may not actually be communicating with the patient themselves. If it's in the case of a minor, you're probably talking to the parents. In the case of a long-term, the children may be the ones you're talking to, and you're not talking to the actual person in the facility. So in this case, because we're no longer talking about a phone call where you can figure out very quickly, it's important that you have a system that can help you identify who is the person that you should be speaking to and what authority do they have to speak to that person. It's kind of back to knowing you're speaking to the right person, whether or not that there's issues on court orders and you need to have elements in place that tell you that, or whether or not you know that it's the father's phone number versus the mother's phone number and knowing which one you're allowed to speak to. Having those mechanisms in place so it's easy to identify, so when you look up the patient and the patient is the minor and you can see very quickly, oh, I need to be speaking about the financial information with the father and about the appointments and the care with the mother, that you know those kind of things. And systems that don't provide that for you just cause you extra effort to figure that out before you do it. And because most of these are records that are stored on the server, those kind of complications can potentially raise some issues for you. Kim mentioned about the idea of the content that is created. In many cases, is considered to be a record. So in the case of texting, I think we're in a little bit of a gray area, and of course the case where we're having a normal conversation, should that content actually be in the medical record, or is it any EPHI? Of course, it's EPHI, the idea is you continue to have it in the record. There are many, many systems and providers right now that might be giving a solution for texting or communicating. The problem is that there aren't necessarily places in the EHRs or the PMS systems to supply that text information. So one of the things you should be looking for is that the third-party supplier of your solution actually has a way to follow the same HIPAA rules about storing that data as if it was the actual primary record, at least until the time frame that we can take all of those records and providers can actually store them in a reasonable location meant for communication. There needs to be a way to have that. So make sure that the provider has a way and does keep those records as permanent and make sure they cannot delete them. There are several solutions that I've seen myself that give you this option to delete content. And I think that doesn't follow in line with the idea of that we are creating some permanent records on the patients. Additionally, when you talk about the storage of this content and following the HIPAA-compliant ideas for infrastructure, many times their large healthcare organizations have their own infrastructure, and they have the competency to build a secure infrastructure around their data, and their systems themselves are secure. Many days, this is all kind of moving to a cloud-based architecture. So my recommendation is that you look at that technology. I have a lot of familiarity with Amazon Web Services. They have HIPAA-compliant technology. You can sign a BAA with Amazon. They have they follow a lot of security rules. They store the data at rest on their servers, encrypted. And when you start taking your technology and you're looking for a way to store that, whether or not it's in your own facility or it's in cloud-based, you need to make sure that that technology can follow that compliancy and gives you the mechanisms to execute that. The likelihood that this data actually gets stolen may be minimal, but in many cases it just doesn't matter. This is what you're supposed to comply with and what you need to do. We talked about this idea of encryption earlier when I was describing encrypted and unencrypted communication and text. If you have a provider that actually supplies you a way to communicate with your patient via text, you're most likely going to want to have these last two items here, both encrypted and unencrypted channels. This gives you the ability to have some choice about how you're going to deliver content. I personally believe that the idea of offering unencrypted is a very important channel to give to providers to offer to their patients, because patients don't understand all these details about encryption and the security rules that are behind all this. They just want text. They just want access. So many times you're going to find that patients will just want to start the conversation via unsecured text, the thing that they're used to doing on their regular cell phones. The truth of the matter is that when it comes to some data that you may think, well, this is actually some pretty serious information. It's not only EPHI, but it's possibly information that is sensitive to somebody's eyes. There's absolutely no way I want to even risk the possibility of having that data go insecurely. And even if you look at the issues of like, you know, does transmission of data, is it likely to get stolen? If I were to send it across my, Verizon or AT&T or Sprint to get delivered, the chances are probably more likely that the walls in your medical rooms are too thin, and you can actually hear somebody talking, and you actually have PHI spread between patients is probably larger there than actually the Sprint or AT&T or Verizon actually losing or letting that data get stolen. But the fact of the matter is the safest way to get, like, say, some medical report or some x-ray or any kind of content that you want to deliver to a patient is to go encrypted. And so that would be a secure channel delivery. The nice thing about having both unsecure and secure channels of delivery mechanisms is that you can start the conversation and start the access with your patient very easily. The barrier is very low, and including the ideas of asking if they want to continue that communication, those are good things to put in place and have. Not every provider is going to have the ability to make that easy for you to get that, the acceptance of its insecure channel. So I recommend that providers have either they put it on their authorization form, or even better, use the technology itself and have a way for you to ask that question right in the text message itself, and so you can get acknowledgement right there, and have a way to have that documented so that you have that as a permanent record that you've got, that you sent the notice and you did that. So when you want to send something that's very sensitive, I like to recommend technology-wise you give the ability to send that to the patient secure. That may be something like you sent a link in the unsecure method, and that link is actually one that takes them to a place very similar to the traditional portals where they could put in the username, password, verify credentials, and then they're inside of a normal application which allows them to text. And then for pretty much everything else, they've given acceptance for to use the unencrypted channel and keep the barrier low, because that's most likely what the patient is wanting. But if you only have one or the other, this is some of the reasons why portals have low adoptance, is because the understanding from the patient is I've got to do all this work and I've got to have access, and a lot of times they see it as a one-time only, so it's a little frustrating for them to do it. But if you give them the opportunity to use unencrypted and they are saying they want to do that, you've given them the opportunity to feel like they've got access and control and they can use the technology for their purposes, but you also can stay compliant. You can have the encryption in place for when you really feel like you need to have that security. In short, if you are thinking about how you're going to implement a text solution, you really have to look at the details of the software and the solution they have. And I know Kim put a lot of information out there. There's a lot to be thinking about, but hopefully the technology doesn't overwhelm anyone when they look at these solutions. They just have to figure out how can they use the technology and still follow the compliance rules that are in place and supply a good technology and a good solution for their communication with their patients. So Kim, I'll hand it back to you.
All right, thank you very much, Bo. So just to kind of finish up with a few action items as you go forward. What do you need to do? Well, you need to make sure that you consider texting and emails in your HIPAA risk analysis, including your IT platform, your mobile devices, any other factors. A lot of times your mobile devices, the information that's on your mobile devices, it's not included in your analysis. If you haven't done so, you need to go back and make sure that that's there. That's one of the key factors when you look at the recent penalties that have been issued by the OCR. They'll look and see whether or not these issues were addressed in your risk analysis. Then, of course, you need to implement the security rule requirements. Secure email or messaging apps, encryption, unique username and password, remote wipes, or other things that you need to do in order to make sure that you comply with both the privacy rule and, more importantly, the security rule. You need to make sure you execute your business associate agreements with any vendors that are actually creating or maintaining or transmitting protected health information on your behalf unless they're a conduit. You need to review and update your policies concerning texting and emailing. Some of the things you may want to address is whether or not that they may text without PHI, the type of PHI that may be communicated via text, the use of encryption or other secure approved safeguards, confirm the recipient before sending the information, to have appropriate steps to make sure you're sending it to the right person, review texts before sending to make sure that they are accurate and they don't have misspellings or improper words in there, limit those texts to the minimum necessary to comply with the privacy rule, make sure you alert and notify people that you got to assume that others nearby may be able to read the text or access the text so that the person using text keeps it secure. Do not let others use that device that has that information on it. Provide immediate notice if there's a lost mobile device. I should note there that in the government commentary, they gave the example of somebody who breached the policies, they violated HIPAA, but the government said in that case, as long as the covered entity had in place appropriate safeguards, had in place appropriate privacy policies and security policies, and trained the individual and corrected the situation within 30 days, then that would not be willful neglect and the covered entity could avoid penalties. But the key there is that you have the policies, the training, the protections in place. Make sure you provide guidance and the process for inputting appropriate information into the medical record. If you're going to be using that information or conveying it, you'll want to make sure that it makes its way into the medical record to comply with your regulations as well as risk management issues. Your policy or guidance should address which text or emails should be input, who may input the text or emails, and who has the authority to act in that way. You should beware any type of bring your own device policies. General rule is if you're in the healthcare area, you probably don't want bringing your own device. If you are going to allow, you better darn well make sure that there are very strong policies and encryption or other safeguards on those devices. But it's very dangerous because it's almost bound to happen that they're going to allow others to use their device or others in their home may access or see information or they may lose the device. Coordinate your policies with HIPAA requirements such as patient access. Are they going to be able to access protected health information that's maintained in those texts or emails, and record retention requirements. Train or educate your members of your workforce, your medical staff, business associates, and others as appropriate. Look for compliance solutions like those that Bo highlighted, the types of things you want to look for. Make sure you're protecting against unauthorized access, encrypting texts and emails, and so forth. All right, if you need additional resources concerning the information we provided, we gave you those written handouts. In addition, the government's website is a great source for all things HIPAA. We have a lot of information on our website that you can access for free, including past webinars on HIPAA-related topics or other items dealing with HIPAA. If you've got questions on any of the things that we've talked about today, feel free to contact me, and I think Bo's willing to probably field some questions too. Feel free to contact us offline, and we'd be happy to respond as we're able. We thank you very much for your participation. Bo, really appreciate your help today, and good luck out there.
Yes, thank you as well.